So we are thrilled that Cecile van der Heijden from Accent Lawyers was gracious enough to accept our invitation to share her expertise and insights with us. A couple of months ago, Cecile published an article in our journal about the European AI Act that raised a lot of interest. And so we thought it was a good idea to discuss some key aspects of her article with our LinkedIn community. Please feel free to drop your questions in the chat as they come up or ask them directly, like in a normal conversation. So thank you so much, Cecile, for being with us today. Please, would you start by telling us a little about yourself and the company you work for?
Yes, of course, Maria. So I'm Cecile van der Heijden. I work as an attorney at law at Accent Lawyers in Amsterdam, where I work on things like the AI Act, but also the interplay with data legislation, including GDPR, the ACS Act, the Data Act, etc. And our firm is very well versed in medical devices, so MDR, IVDR. And that ties in very closely with the AI Act and the data legislation. So thrilled to be here.
So, okay, thank you, Cecile. I hope it's not that hot where you are right now as it is here in Barcelona. I'm Barcelona based, so. Okay, let's get to the point. What is the main objective of the European AI Act?
So the idea behind the AI Act is to assure safe, trustworthy, and high-quality AI across the EU. From a medtech perspective, it also means the integration with the MDR and IVDR, which should be done, if according to plan, without stifling innovation for the sector.
Okay, and how does it aim to balance innovation with regulation? Because I suppose it is a big hurdle, isn't it, with all the regulations already going on, and there's another one now. So, what's the balance here?
Well, I'm glad you said aim, because what we see in practice is that there are a lot of unclarities still that need to be resolved. So there is the intent in the AI Act, especially in the now final text that has been published in the Journal of the European Union, to integrate the AI Act into the system that we already have in place for medical devices in the MDR and IVDR, which means that the conformity assessments are to be integrated. There's a clause that allows you, where possible, to integrate the documentation and the processes required under the AI Act into the processes and documentation that you already have in place in the MDR and IVDR. There's also a very much a risk-based approach in the AI Act, although it unfortunately does differ a bit from the one we have under MDR and IVDR. Because the AI Act, where it comes to medical devices, just has a binary approach. It's either an high-risk AI system or not.
I'm just listening.
And otherwise, so there's no risk division as we have in the MDR and IVDR with 4 different risk classes. So that's a bit different, but it is risk-based in that respect. There's also a setup for controlled environments which apply, for example, prior to market release. So that's also intended to allow innovation within the AI Act. So there has been quite a bit of thinking about integration, but what you shouldn't forget about the AI Act is that it's horizontal legislation. So in the end, it needs to cover a lot more products than medical devices under MDR and IVDR. And the consequence of that is that there are some things that haven't been arranged quite well, simply because of all the other products that also need to be covered here.
Yeah, that's what I found very interesting. That most legislation, or the ones I know about medical devices, they are rather vertical, and this one is horizontal and has to fit somehow. So that's really intriguing. Maybe we can talk about that a little later. For now, I wanted to ask you, how does the AI Act define an AI system, and why is this definition broader than commonly expected?
Yeah, so It's machine-based setups that can infer patterns, can learn, and produce outcomes based on input. And those are, for example, predictions, decisions, etc., which affect the real and virtual environments. So the issue with the definition here is that we have guidance from the European Commission about the definition, which are written so broadly that almost all traditional medical device software will fall into scope, because they all infer something based on input resulting in output that has impact on healthcare, on the health system. That's not necessarily an issue if we look at the guidance we have about medical device software. From the MDCG, where we also see that there's a very broad scope, but it means that almost all medical device software will fall under additional regulation, which means the whole hassle of new additional conformity assessment for the AI modules, the documentation, the QMS, the post-market monitoring obligations, which all are kind of similar to the obligations that we know in our MDR and IVDR, but also don't align completely. And that means that there will be quite significant implementation hassles for companies, and it also means that there needs to be an overarching strategy for those companies to align with this legislation, but also with the additional legislation that we have coming in from Europe with respect to, for example, data or environmental requirements. So yes, this is a key piece of legislation, but it also needs to fit into your overarching legal strategy, and that's what makes it so challenging if you fall into scope again.
Do you have the feeling that companies were a bit prepared, or are they coming to you in panic, asking for any advice they can get?
Well, the companies are starting to draw up quite a bit of strategies with respect to the AI Act. And I think what really helps is that this is also a product regulation. My experience is that data legislation is a lot more difficult in the uptake compared to product legislation, simply because it again directly concerns your product and your ability to place your product on the market, put it into service, or keep it on the market or in service. So there's a lot more a feeling of we need to make this work. What doesn't help in that respect is that we're still requiring quite a bit of clarification and guidance. All of you are aware that that we don't even yet have all the MDR and IVDR guidance after 7 years. So that's obviously a hassle in setting up a strategy, but hopefully we'll get a bit of guidance sooner than later.
Yes, strategy doesn't go with improvisation very well, does it?
No, it really doesn't.
Yeah. So as we are talking mostly about medical devices in this session, I wanted to ask you what qualifies an AI system as high risk under the AI Act, and why are most AI medical devices and IVDs included in this category?
So it's probably good to first mention that the AI Act does recognize several types of AI. There's high-risk AI, low-risk AI, which isn't mentioned directly, general purpose AI, but for MedTech, it's the high-risk AI to focus on. Article 6.1 of the AI Act states that if an AI system is either a safety component of a product, or the AI system is the product itself, and the product's covered under legislation listed in Annex 1 of the AI Act, and the product is subject to third-party conformity assessment, then the AI system qualifies as a high-risk AI system. Now, Annex 1 explicitly lists the MDR and IVDR, and most medical devices do need to undergo a conformity assessment by a notified body, so by a third party. There's only an exception for Class A IVDs and Class 1 medical devices, except for the measuring, reusable, and the 1R, the 1S, and the 1M devices. So the consequence is that almost all medical devices that qualify as an AI system are also immediately high risk. Consequence of that is that the most significant requirements under the AI Act apply to these medical devices. Then there are also devices that don't necessarily qualify as under the criteria I just described, but they are listed in Annex 3 because they are used, for example, for triage to determine who can get access to healthcare without having a medical purpose themselves. And for that, there's also the Annex 3 lists categories of AI systems. And if the type of AI falls within one of those categories, it's also high risk, even though it wasn't technically a medical device or an IVD.
Okay, thank you. Does anyone have a question about that? Because this is quite crucial for some of you guys, I think. So if you have any question seeking guidance, just say it or drop it in the chat. I will be happy to read it out loud. Or, I mean, not only about this, but everything that has been said before. If you have anything to add or ask, please do. Okay. I wanted to know, I mean, I know more or less, but do other jurisdictions have similar provisions concerning AI in healthcare or in general?
So I think Europe really is setting the golden standard again. We saw the same thing with GDPR actually, where other jurisdictions started implementing similar legislation after we did in Europe. But the US, certain states in the US have some legislation on AI. FDA has obviously guidance with regard to software as a medical device, so that's always interesting to keep an eye out for changes with regard to AI. Canada, I think, is working on AI legislation, but I don't think it's been implemented yet. And I've also heard something about China, but I'm not that well versed in Chinese law, so bear with me if that's not not on the table anymore. But I think this is a first again, and the issue with being the first is also that you can't work on the basis of other people's or other countries' experiences, and that will always be little child's diseases that still need to be covered after implementation.
Yeah, and hopefully they can all be aligned somehow, because that's a major issue, no? If you market across markets, then
Let's hope for it, but
yes,
don't be too hopeful because
yeah, it never happened before.
no, and jurisdictions have their own priorities and their own political agendas as well.
Yeah.
I mean, in the end, legislation is as much politics and compromise as it is simply wanting to regulate something.
Yeah. So I have a question here from Courtney. I will read it out loud. Do you see many examples of Class A or 1 software? I see mostly C and 2 and above. How common will that be?
I think it's going to be C and above, so Class 2, A, B, 3 for medical devices. There is very little Class 1 software, but it's important to mention that for the few software products in Class 1, they could still be an AI. So, but I don't expect many of them in the next couple of years coming up.
Mhm. Thank you. And I have a second question from Arpita. She asks, what kind of AI systems are product itself? Are all MDSW products in itself? If a standalone MDSW incorporates an AI system which is not critical to the IU of the MDSW and does not have a safety function, does this AI system qualify as a high-risk AI system?
So there's no formal guidance. Let's start there. But I think in this case, look for working with modules, because that might help you to keep things out of scope. And that's allowed under the NDCG guidance on medical device software. So I would definitely consider that option.
Mm-hmm. Okay, thank you. And there's a long question from Rana. She refers to the last week's publication of the MDCG and AI board, who published their joint guidance on the interplay. You posted that on your LinkedIn page, Cecile, also. And she mentions Rana, she mentions some classification details and so on. And I think the bottom line of your question, Rana, is that it means that some of these classification rules mean that notified bodies are not required for certain high-risk medical device artificial intelligence. What is the rationale behind this? That's the question, basically.
Yeah, so the intent is that there won't be two conformity assessments. The intent is that you'll have a single conformity assessment that you undertake already under MDR and IVDR, and that the AI Act aspects are integrated into that, which is sensible because the product needs to go to market as a whole. You can't put half the software on the market. The problem, however, with that is the initial certification cycles, because many products are already on the market. And then are already so they have their CE marking already, and then they need to tack on once the relevant aspects of the AI Act come into play. They need to tack on the AI conformity assessment as well, because it is part of the conformity assessment. And notified bodies are still quite a bit over the place how that's going to work. So what we'll see in practice is that there needs to be a solution for this bridging situation. Because I really hope that doesn't mean a new conformity assessment under MDR and IVDR to integrate the AI Act. That would be a waste of money, a waste of time, and a waste of strategy to integrate. So I think that's good to have as a background. So Annex 3 devices, Annex 3 devices are a bit different. And there is an annex for that that describes the procedure for the conformity assessment there. I don't know that one by heart because I've been really focusing on the medical device, on the medical device AI Act, but it is a different procedure. So if you're out of scope of Article 6.1 and you end up in scope for Article 6.2, so under Annex 3, you need to look at that additional annex for that.
Okay.
Thank you. That clarifies it. I also had the same concerns about how this would overlap eventually with notified bodies under IVDR, MDR, because it doesn't make sense to have such a strict separation between the two.
No, it doesn't. And it's not intended to be in the end. It's just that nobody actually thought about how the integration timeline will go. Ideally, I think your notified body will set, I hope they will do this, will set up a procedure where you can get a top-on conformity assessment for the AI aspects, which maybe then should have a shorter lifespan, because the certificates will always be a maximum of 5 years, on both under MDR, IVDR, and AI Act. And so that once the new cycle starts, the conformity assessment can be integrated, and you can just have one conformity assessment. But it's a struggle, and we don't have information on how this is going to roll.
There has been talk about training notified bodies on AI.
I think that would be very helpful. I was at a conference recently where we were wondering about, amongst ourselves, about AI literacy amongst regulators and notified bodies. So great idea.
Yeah, actually, that's part of your article, isn't it? That the literacy is another thing because not everybody is already familiar with everything concerning AI. I mean, it's fast developing, so
No, and that also really applies to everyone that uses AI. This is not a
exactly.
manufacturer provider issue, so it's a party responsible for developing and placing on the market. This is an issue for everyone who even uses AI to write a difficult email to a client.
Exactly.
You need to have knowledge about how AI works, what it does, what it can't do, and also how you need to do that. The implement the AI literacy. That's not clear either. So my advice would be, and this obligation already applies, but there's barely any guidance. So the only helpful thing I found is a guidance set by the Dutch Data Protection Authority, which is available in English. So if you Google DDPA and AI literacy, you'll find it. But what they say is this is a reoccurring process that you need to keep going. It's almost like a lifetime obligation under MDR and IVDR. You need to continuously monitor. You need to have a structural plan to identify the needs. You need to adapt that plan. You need to implement it, and you need to keep doing that. So AI literacy is not a one-off. It's really something that will remain relevant as long as we have the AI Act, and that's sensible given all the developments that we have.
So Courtney here, she has some insight. She says that she can confirm that notified bodies are doing AI training. She posted that in the chat.
Great.
And she has another question. MDCG 2025-6 allows for continuous learning within predetermined bounds under the AI Act. Do predetermined change control plans I suppose this means it says chance, but I'm not sure. Do predetermined chance control plans pose any problems from an MDR/IVDR point of view?
Yeah, so to give a bit of context for everyone, there's a grandfathering clause in the AI Act. It's Article 111.2, which states that the AI Act applies to high-risk medical devices from 2nd of August 2027. If a device is already on the market before that, an AI medical device AI system is on the market before that, and it undergoes any changes between that date and the 2nd of August 2026, then it actually, if the change is a significant change to the design, you need to, it falls into scope of the AI Act. So you can stay out of scope of the AI Act unless you have a significant change after the 2nd of August 2026. And it's not defined what a significant design change is. So in that respect, the guidance was actually a bit helpful. I know I was rather negative about it on my LinkedIn. But if you're setting up the predetermined change control plans, you need to also consider under the MDR and IVDR whether it triggers a significant change there as well. So you need to align both regulations here. So it's not necessarily a problem, but it could be a problem. And it will be device specific. And I would probably talk it through with my notified body if I were a medtech company.
Okay, thank you. We met last week briefly on the phone, Cecile, and we discussed this webinar. And you mentioned that it might be interesting to be aware of other legislation too, such as the EDHS Act or NIS2, the Data Act, and so on. Do you mind elaborating a little bit?
Of course. So this is what I love, the interplay between the regulations and building architectures out of that. Because what I've seen companies do, especially the somewhat bigger companies, they think in silos. Not every company, of course, but it happens a lot. And the issue with all the legislation, not just the AI Act, but also the data legislation and the cybersecurity legislation, is that it requires you to think overarching and to bring things together. For example, the MDR has security requirements. GDPR has security requirements. we have the NIS2 directive coming, which should have been implemented by now in national law, and it isn't in many places, which also deals with cybersecurity for specific devices in certain public health emergency situations. And if you don't bring everything together, you'll be scrambling to catch up once you need to implement a new regulation because the teams don't talk. Same thing is with the European health data space that's coming up. Has already been adopted. The act has entered into force, but it doesn't apply yet, which requires, for example, making available of electronic health data, which includes personal data for secondary use purposes, which includes training of your AI. But if that information is still if that information is still personal data, you can't take the data out of a secure processing environment. Now, I've heard sounds that the secure processing environment under the HDS Act is actually seen to be as being a sandbox under the AI Act. So all these regulations all tie together, and you really need to think about, okay, if you look at the AI Act, how does it tie into MDR, but also how does it tie into GDPR as well? And how does that tie into secondary use if you collect data for training your AI? And where can you get the data? So that's where the EHS Act comes in. So maybe another interesting tidbit, which annoys me greatly as someone who does a lot of data protection legislation advice work, is the fact that Annex 5 says that the provider of the AI system needs to declare conformity with not only the GDPR, but also the version of the GDPR for EU institutions, and with the directive on the use of personal data for police purposes. And you need to tell you need to say in your declaration of conformity that you're compliant with all these regulations, which obviously you can't be. You're not an EU institution as a simple medtech company. You're also not police, and also GDPR doesn't regulate products; it regulates parties. But all these regulations come together, and it means that you really need to go high over with your strategies, and you need to have teams talking to each other. It isn't enough anymore to be just an expert on your product. You also need to, but you don't need to be an expert on everything, but you need to know who to talk to, who's an expert on the other topics. You can't regulate these things individually anymore as a company.
Yeah, that would be really interesting, yeah. Because, I mean, maybe AI will be able to help, I mean, the language-based AI, learned language-based, to handle all these different regulations somehow. But as we said earlier, you have to know how to handle them. So there will still be, we will still need persons who are really proficient in this material. I mean, it's just too complex, isn't it?
Yeah, I mean, I'm a lawyer. I go very well on difficult puzzles. So I say, yes, it's complex with a smile. But if you're a company, obviously, this is really annoying because there's so much legislation coming out.
Yeah.
So I completely understand how that feels from having to implement it. But I think building these structures also helps you if you want to broach to other markets. However, you always need to be very carefully think about, what am I implementing? Because we just mentioned the EHS Act, which really says you can't take the data out of the secure processing environment if it's still personal data. But if you want to go to Japan, I believe Japan wants to see the raw data. Well, that's going to be an issue. Your notified body, if you train your AI system in the secure processing environment, will also want to see that data, but you've obtained a permit to gain access to the data, in which you need to list persons who will have access. So it's going to be so difficult, and you need to be aware of what's happening all the time, and you need to think very far ahead.
Yeah, interesting times. So I have another question from Ina, and I just wanted to say that shortly we are running out of time for this session, but I will post a link in the chat to have a follow-up meeting. So everyone, if you can look at the chat and activate the link that I'm sending, it's a follow-up session where we can answer more questions that you might have. But for now, I will ask the questions that Ina has. and we can finish that one and then start the new session maybe. Okay, so the question Ina has, do you have specific recommendations, approaches, strategies for companies to overcome these silos? Are there digital tools that you have found to work well?
No, not tools necessarily, sorry. So I see think of a Greek temple. It's an analogy that I use for this. If you have the Greek temples that we see now, they are just the pillars, and the pillars are all separate. What you need to have is both a base and a roof. So you need both from the bottom up and the top down, something that connects the pillars, because you have the teams, you have the expertise in the various teams, and you can't expect people to have the expertise overall. But what you want to do is to make sure that people talk and that people are aware of legislation. So you need to have a base level of knowledge what's out there, and then the gremia to have people actually communicate, exchange, and to do that at the exact right time. So it really has to be, GDPR has the terminology privacy by design, privacy by default. You need to implement that actually for legislation as well, not just privacy, but the by default and by design parts. Because by design means that you do it from the first start. You don't think of, oh, we're making a very nice product and we need to implement data protection and environmental later. No, it needs to be from the start. And by default really means that that's your natural setting, that you're implementing everything, and that you're continuously thinking about it when you are working on the device strategy. Now, how you do it in practice will depend on your company. I would always start with a bit of integral learning across teams. And that's simply to create the awareness, because without awareness, you can't bring things together. And I just mentioned the Greek temples, so the roof structure, that shouldn't be management actually, because management is managing. They are not a product experts and they're not a subject matter experts. So you need to integrate that at a lower level to make it actually function sufficiently to bring the best product to the market and to help all the patients.
Okay, should I ask my next questions? But as I said before, please all feel free to just drop your concerns, no problem at all. Cecile is so gracious, she can answer everything spontaneously. That's really cool. Thank you so much. So here's a bit complex question. In what ways does the AI Act differ from the MDR and IVDR? And where are the main alignment challenges for medical technology companies? I mean, we already said some stuff, but maybe you can share some more light on this, Cecile.
Yeah, of course. So I think we had a risk classification, but that also means that the medium risk devices, especially the class 2A or the class B IVDs, now have to comply with the high risk requirements of the AI. So for companies that can be a bit of a switch mentally. What we see is that the AI Act really has different focus. So it goes beyond the clinical safety of what we need to establish for medical devices, and it really sets requirements for training data, for bias monitoring, for explainability, and it really has a focus on fundamental rights. So if you thought, well, great, I'm not a data protection expert and I don't need to be, actually data protection is coming in through the fundamental rights focus of the AI Act again, apart from all the other requirements. So for me, what's the most interesting thing to look at is the other data requirements with regards to data governance, because the AI Act really sets more stringent requirements about representation than the MDR and IVDR do. The device really needs to be, the data sets used for training, validating, and testing the AI really need to be representative for the patient population for which you'll use the device. They need to avoid discrimination as much as possible. So you need to think about which bodies am I not seeing in my studies, for example. Which data don't I have? And that goes beyond a risk management that we do for the risk-benefit analysis of a medical device. technically, yes, that information should be in your risk analysis, but we also know that men are more participating in clinical trials than women do. So the AI Act really asks you to actually be wary of that and to take steps to amend that. Data needs to be error-free to the best extent possible. It needs to be relevant. It needs to have appropriate statistical properties. So this also asks something of your data collection practices under MDR and IVDR. Because you really need to think about, okay, do I not only have sufficient data to prove that the device is safe, but also have I actually brought in all the groups on whom the device is intended to be used? And that does ask a different way of thinking about data. You also need to actually monitor the device for bias, and you can't, in the ideal situation, you can't use personal data for that. So you need a strategy for bias detection and correction as well. Only if you can't do it with things like synthetic data, you can bring in personal data. So that's something that you need to be aware of, because under MDR and IVDR, through post-market surveillance, we're focused on patient data. But that's not automatically what you can do for bias detection. There are questions we can raise about clinical research. There's an exception in Article 2.8 for pre-market research, which should fall under the regulations which cover the product, so MDR, IVDR, except in the case of real-world testing, so outside of an environment that's set up artificially, which obviously medtech companies are doing during clinical trials. So there's a problem there that still needs to be resolved. The MDR and IVDR have the concept of post-market surveillance. The AI Act has post-market monitoring, which is somewhat similar but not identical, because it's much more focused on the fundamental rights of the natural persons on whom the AI system is going to be used. So these are all aspects that you need to bring into your device strategy to keep the device on the market under both regulations. And that's going to be complex, but also very interesting, at least for me, to see how this is going to play out. And I think we need a lot of guidance and clarification from notified bodies, regulators, Europe, which you still don't all have. So there are areas that we can't resolve just yet.
I mean, some aspects I even find necessary, to be honest. I know that you are a femtech expert, and I loved your comment about the clinical investigations and the imbalance of study objects, because it's still not, it hasn't arrived in our consciousness, has it? Every time I talk to men, I'm sorry, they are just not aware. They think, no, but everything is going well. But it's very biased. I mean, that's the probably most prominent example. But nowadays, you can bias anything so heavily. And femtech, I mean, the imbalance between the genders is just one blatant example, isn't it?
It is, and you see exactly the same thing with regard to different ethnicities. It's the
Yes,
white man
exactly.
who's mostly in the trial, and that may have something to do with the reach or the risk averseness of other people. But the AI Act really asks you to be aware of this, and you really need to start thinking about what I call equality by design. How do I bring in the bodies that are not there to meet the data requirements of the AI Act? And I think you could have questions about risk stratification under MDR and IVDR as well, if you don't address half the population in your data. At the same time, what we see is that the US has policies with regard to things like gender and diversity, which will mean that data from the US will become less trustworthy. Now, I haven't seen examples yet of competent authorities and notified bodies asking questions about the validity of US studies, but I wouldn't be surprised if that's coming in. So the US as a data collection market might also be in danger. And these are really things that you want to think ahead of, because if at a certain point a regulator or notified body starts talking about US data doesn't suffice anymore, you need to do follow-up studies in Europe to make sure that you have all the data that you need, then obviously that's going to delay product launch. So it's it's not even just the European legislation, it's the whole package that's influencing this.
Does anybody have a specific question about this or a comment to add? I'll just give you a few seconds, because if not, I will ask the next question for you, Cecile. What ethical or compliance considerations must be taken into account when developing or marketing AI tools in healthcare? Again, everything is intertwined, and you mentioned already some things, but maybe you want to elaborate a little bit?
Yeah, so here we see a lot of the things that we already saw coming by. So data protection. The AI Act doesn't set aside GDPR. So there's still the personal data from sensitive categories that we need for our devices. So data governance is going to be key. We have the prohibition on discrimination and bias, and we have the to do bias detection. But the problem with discrimination is that with medical devices, especially given the context in which we test them during clinical investigations or performance studies, may mean that we haven't seen everything. So you need to set up procedures that allow you to detect unintended discrimination that you just weren't able to detect prior to the device entering the market. Anyway, the AI Act is really heavy on on post-market review and post-market access. Deployers also need to make sure that for high-risk AI systems, so deployers are the users in a professional capacity, they need to make sure that the device has human oversight. So obviously that's the deployer's problem, but you as a meta company need to make those that human oversight possible in your device. So you need to be able to explain why the device does what it does, how to stop it when it does something it shouldn't do. And that's also part of your strategy. You need to ensure that your data is inclusive enough. You need to monitor that it remains inclusive enough. Think, for example, about products that are focusing on a disease that presents differently between ethnicities or between genders, as we just mentioned. It's fine if it targets a single country in Europe, but if you're expanding to an entirely different region of Europe, so say, for example, your product's targeting hospitals in Sweden, and then you want to go to France, which, especially in the south, has also a North African population quite a bit, then you need to think about, is this device still good enough and inclusive enough in its training data? Do we need to retrain it? The post-market monitoring really means that you need to be wary of all the real-world conditions and the fundamental rights. So that means going back to the legal requirements for fundamental rights, right to private life, right to family life, you name it. If the AI influences it, you need to be aware of it. So you need to consider this during the design process as well. What's also really interesting, it's not necessarily ethical, but is incident monitoring. Under the AI Act, what we see in practice is that reporting will be done to the same competent authority. Incident reporting will be done to the same competent authorities as we have under the MDR and IVDR, but there are two separate reports that need to be made in case of the same incident. And that's also, the definitions don't align, because under the AI Act, incidents with medical devices are things that impact the fundamental rights of a person. Now, again, taking data protection as an example, so if you have an incident with patient data, that's an MDR notification, an AI Act notification if you're unlucky enough, and the GDPR notification. Those are three separate notifications that you need to do at around the same time. They don't have the same timelines. So that also asks something of your intercompany setup for these kinds of things. So the AI Act really impacts everything you do with your device and everything you do related to your device. So compliance is going to be interesting, I guess.
Yeah, there will be a lot of pipeline experts in the companies, I think. One triggering the other, no? Or I mean, I suppose it will be a chain, or maybe it will all be at the same time. I don't know, but yeah, interesting. Okay, I have one last question for you, unless somebody wants to comment something. But we have also time after my last question. If you have any very specific concerns that you would like to share with us. So my last question is, what are the key compliance deadlines that medical technology companies need to be aware of between now and 2030? That's a very specific question.
At the same time, there's still a lot of interpretational issues here.
Ah,
So as I said, 2027 is when the high-risk AI requirements apply. But if the device is already on the market, it shouldn't undergo a design change after 2nd of August 2026. Well, that's relatively clear still. This can be found in Article 111 too. And there's this interesting additional clause which says, in any case, the providers and deployers of high-risk AI systems intended to be used by public authorities shall take the necessary steps to comply with the requirements and obligations of this regulation by the 2nd of August 2030. Now, that doesn't sound relevant maybe to you at hearing this first. But the interesting thing is that public authorities can be healthcare providers. Healthcare is listed as public authority. It may not be every healthcare provider, but it could be. And that could mean that if your device is intended to be used, for example, in a state-run hospital, then it might become subject to this deadline by the 2nd of August 2030, even though it was subject to the initial grandfathering, because it was not amended in its design after the 2nd of August 2026. Now, this may not be interpreted like this by competent authorities, but you need to account for the option that it does at this moment, because we don't have the clarification yet. So that's going to be interesting. Also, if you have a general purpose AI, which is not high risk as such, then it should comply by 2027, if it had 2nd of August 2027 as well. But if you're integrating your general purpose AI into a medical device, then it becomes a high risk AI system, and it falls under the grandfathering clause that we just discussed, unless it's placed on the market after the 2nd of August 2027, when it just needs to comply as a new device. So there are still some interesting questions that need to be addressed here.
I have a question. Thank you, Cecile. Sorry. I have a question here from Tina. It says, she says, it says in the MDCG 2025-6 that the guidance provided in this document is without prejudice to the guidance that the European Commission may adopt on the basis of the AIA. What should we expect based on this in medical devices scope? More interplay guidance?
I think the European Commission really is focusing on the general aspect. So they've said something about AI literacy, which was completely useless, by the way, sorry for that, and on the definition of AI systems. So what they will focus on is the general topics that apply to all the legislation and all the products that fall under the scope of the AI Act, and not just medical devices. I think we need to look at the AI board and MDCG to get the interplay guidance. And it's sorely necessary, because there are all these issues still that need clarification and need take, for example, the timeline issue that I just mentioned with the 2030 deadline. That needs to be clarified now, because you need to start planning for it as a company. So I wouldn't look at the European Commission for the essential guidance in this respect. I think it's mostly going to be MDCG, but it's also really important, of course, to take note of any general guidance, because you never know how you could amend it to fit for MedTech as well.
Okay, thank you. So we are now open. We have a little time left for any other questions that you might have. Or Cecile, if you want to add anything where you thought this has come short, maybe, please feel free.
Yeah, I think maybe one last thing I would like to say is start preparing. because we have the MDR and IVDR certification deadlines for the companies who are still in transition, which quite nicely align with the AI Act, actually. So those need to be considered. We have the EHS Act coming up, under which the making available of data for secondary use is going to apply from 2029 and to 2030, which also mean that you need to do something with your company infrastructure in regard to data. We have the NIS 2 directives implementation coming up, which doesn't always apply to medtech, but it could in case of a healthcare crisis. So bring the environment together and don't just look at the single deadlines of each individual legislative framework and think, oh, I have some time. Because if you need to do all these things together, you don't have time. You wish you started 3 years ago if you could have. So just don't wait. I think that's the main message I want to give you.
Good advice, yeah. So at the moment, nobody else has a question, so I think we can wrap it up here. Thank you so much, Cecile, for your time and for explaining everything to us. I think everybody who signed up for the meeting can see your LinkedIn profile, so they can send you messages with follow-up questions, maybe, if you don't mind. And I will send a message to everyone who attended or signed up as soon as the recording becomes available. And that's it. Thank you, everybody, for joining us and for participating and for making this so interesting. And have a good lunch now. It's time.
Thanks so much. Yeah.
Thank you so much, everybody.